Okay. All right. Good morning, everybody.
Good morning, Tracy.
Good morning.
Welcome to our Property Management Leasing Council meeting virtually. Sorry, I'm getting feedback. Let me get that out of there. We have this, I believe, is the first one, so I'm really excited about it, and I'm glad you all could join us. It's myself, Tracy Lewis Van Camp. We have Lee Halliard here, and I'm not sure if our other co-chair, Amy Gianni, is here or not. If you are, say hi. Just want to talk about that we are glad to have everybody. We're going to mute you while the presentation's being done. So please use the chat feature to ask any questions that you may have. And then we'll go from there, and John will answer the questions either during or after the presentation. Is there anybody new that hasn't been to a Property Management Leasing Council? I'm looking at some of the things. Some people say they can't hear, so maybe turn up your volume. I'm not sure what would cause that. But the good news is this virtual meeting will actually count towards your Circle of Excellence for this year. So the minimum is 3, and this will count as one of the 3 meetings. That's why we asked everybody to register for the meeting. We also have upcoming Zoom meetings that is HRR's Closing in the Time of COVID-19, which is on April 23rd, also at 11 a.m. And I believe attorney Brett Thompson will be presenting that. So make sure you mark your calendar for that meeting and also register for that meeting. So without further ado, I'm going to turn this over to my co-chair, Lee Halliard, to introduce our speaker.
Good morning, everybody, and welcome.
Good morning.
Good morning. This
morning, like you, I have questions, you have questions. Between all of us, we probably have more questions than Dones makes little pills. So to help us navigate through this situation we all find ourselves in, please join me in welcoming John Captain, who's going to be taking our questions and providing real-time answers to us. John, thank you for being here.
You're welcome, Lee. Thank you for the introduction. Are you ready for me to start the presentation?
Yes, indeed. We're ready.
Excellent. Well, property managers and landlords, I'd like to offer my condolences because we are in difficult times. We at HRR and as a law firm want to assist you the best we can and want to do our best to address the very recent and ongoing changes in the law and how it affects your business. I have titled today's presentation, How to Weather the Storm, because I can't make any bones about it. I don't get paid to give only the good news. I got to give you the bad news too. And unfortunately, we've had a lot of changes. We at Hanger Law pride ourselves in bringing peace to the process and clarity in uncertain times, but we need to start with the uncertainty before we can get to the best practices. So what I intend to bring to your attention are the recent changes in both state and federal law, help identify what is certain about those changes and what remains to yet be clarified further, and how you avoid liability during this process, and to give you the tools and resources to do your best in the uncertain times to make the best of a very difficult situation. And there's no 2 ways about that. The information at the bottom of this slide gives my contact information should you have questions after this. I would like to provide a legal disclaimer that this is not intended to be individual legal advice or a former attorney-client relationship. However, this is supposed to be informational to you as part of your membership in the Property Manager Leasing Council, and hopefully it provides a little bit of clarity in difficult times, and there's the HRR information below. I'm going to give it a second to update. I tried doing a dry run and there was a little bit of lag. But to introduce Hanger Law, we're a full-service law firm serving all of Hampton Roads. We have offices in Newport News, Chesapeake, and Virginia Beach. We're a proud affiliate of HRR, and usually we're in good times looking to help small business partners, landlords, property managers expand their business and build. But we're shifting to try to help survive difficult circumstances, give the best advice that we can, and allow our business owners and property managers who are out there taking risks, providing valuable services and homes to tenants in the community to be able to continue to do so for a long time coming, even on the other side of this current crisis. A little bit about myself. I've been a Hampton Roads resident for the last 16 years. Prior to getting into the law, I was a naval officer and a realtor or a real estate agent myself. I specialize in real estate contracts, sales, contract disputes, small business formation, and landlord-tenant law. And I love my greatest satisfaction is when I can equip small business owners to survive, expand, grow their business, employ people, provide meaningful goods and services to the community. And I hope to do that today. But launching right into it, we've had substantial recent changes, and they've happened on two fronts. Virginia, the state level, is traditionally where real estate law is generated in the General Assembly and enacted into law by the governor. Now, typically, that law change process happens over time, where there's proposed changes, the public can comment on them, industry is consulted, and when there are new changes, there's typically a rollout period, 3, 6, 9, 12 months, so that business can prepare and to pivot and be able to make changes to adapt to the new laws. That hasn't happened in this case. There is unilateral action from different branches of government. We've had executive orders from the governor that impact landlords and property managers. We have a judicial emergency, and then we have variation on how those two sources of legal changes are being interpreted, and so that individual courts are interpreting those guidelines as to what is an essential proceeding and what isn't differently between the jurisdictions. And then on top of that, we've had the federal government get involved into an area that is not traditionally regulated by Congress through the CARES Act. And that creates a sort of a not quite interlocking web of uncertainty. In my federal prior practice, I had to rely on the Congressional Research Service, which is very well-trained lawyers. And I read the CRS brief on the CARES Act, and even they said, this isn't clear how this is going to work out. So we're going to give you the most certain information we can, and I'm going to try my best to make it clear where it's not yet certain how things will pan out. And be advised that things may change tomorrow. I think it is very likely, though by no means certain, that the judicial emergency that has closed the courts through April 26th shall be extended another time. It was originally through April 6th. And I think it's going to be extended again. I'm not certain. Last time it was March, I think 31st that the extension was announced, or it might have been March 27th. So stay apprised. We're going to do our best as a firm to inform our clients as up to the minute as possible as to these changes. But these guidelines that I'm going to provide today are good for today and may need to be adapted as future changes happen. But I'll tell you what is certain. The temporary emergency is a judicial emergency. The most clearly impactful of these changes has come down from the Supreme Court of Virginia, declaring a judicial emergency. It was initially announced on March 16 through April 26. The executive has declared an emergency through June 10th. Both of them may be extended, but we know that through April 26th, the courts are closed to non-emergency matters. There's a moratorium on evictions, and that has actually come from the Attorney General, who is an executive branch but independently elected official. That means that unlawful detainer filings are stayed and continued. It won't be accepted. Now in Virginia Beach, the local guidance says that you can have a July date and you can file new eviction proceedings. They're interpreting it differently. I looked at the 7 cities individual pages last night, and I believe, if I recall correctly, that Virginia Beach is the only one accepting these filings. Some of the other courts are not accepting warrant and debt. I had given a webinar about 2 weeks ago, and the courts have updated their website since then, and I encourage you, if you do not have your own legal counsel and do these filings typically yourselves, to stay up to date with the individual locality in which your properties are located's website. So I took a quote directly from the Virginia Supreme Court Emergency Declaration. The court shall continue all civil, traffic, and criminal matters, including jury trials except for emergency and other matters as provided in this order. For example, routine proceedings including but not limited to non-emergency warrants and debts, unlawful detainers, which are issuance of garnishments and writs of eviction shall be continued during the period this order is in effect. Now again, the different localities are interpreting this slightly differently. We have clients who had filed unlawful detainers prior to the eviction, but did not had a court date scheduled. Some of those have been continued to right after the emergency is supposed to be lifted at the end of April and the beginning of May. We have May dates that are still currently on the books for those unlawful detainer hearings. And some of these jurisdictions are just merely not accepting new ones. This does not, there is nothing in the law currently that is retroactive to prior to the emergency declaration on March 16th. So if you have pending cases, you should be able to follow those through when the courts reopen. Nothing in either the state or the federal law has lifted the obligation of tenants to pay rent. They have merely suspended the landlord's remedies. When we get to the CARES Act, well, I'll just say it now. There's ambiguity regarding late fees. The language in the law is not clear. It reads that late fees shall not be charged during the 120 days after the CARES Act was enacted, but that's not clear as to whether they cannot be accrued and then charged later. I would counsel to keep a balance sheet and exercise reasonable accommodations upon request. I certainly wouldn't charge those during the 120 days, but it does not say, it does not explicitly prohibit that those fees will not accrue should rent be late or not paid during that period of time. So I say that I hope you hear the grain of salt that I'm attempting to put into my voice, because there are things that the law says clearly, things that can be reasonably inferred from the language, and things that are outright ambiguous. And I think that creates an outright ambiguity between charge and accrual. That may sound like lawyer speak to you, but it's going to make a difference for your pocketbooks. Moving on. The Federal CARES Act. Again, the federal government is not traditionally the source of real estate regulations, and yet it jumped in a big way in the CARES Act. I think it's section 4240, if I'm not mistaken. I don't have it in front of me here. But this restricts the filings of new evictions on all covered dwellings for non-payment of rent for 120 days from March 27th. Furthermore, and this was not clear to me when I provided the last guidance, I had talked about the 30-day requirement. In Virginia, we rely on a 5-day notice and a 21-day pay or quit notice. These are obviated, they're gone. That doesn't count, you can't do it during the next 120 days until this is up. Furthermore, it says that you cannot evict a tenant without 30 days notice, and that the issuance of notices shall be suspended during this period for covered dwellings. So a reasonable construction of that language in the law is that for 120 days, no new evictions can be filed. No notices can be filed subject to state law. A 30-day notice is required, but a 30-day notice can't be posted until the end of the moratorium, which may mean that no eviction can proceed until August 23rd or August 24th. I would counsel that you should file as soon as the moratorium is lifted if you have a covered dwelling, and believe that as a matter of practical concern, the courts are not going to be caught up in August with this backlog that is going to be created during this emergency. So I would file as soon as practicable. I would notify as soon as it is legal. And again, I don't want to stray into the matter. I consult with your own attorney on this, but I would consider these measures to create defenses that will be the burden of the defendant to raise at the time of hearing. Do not hear what I'm not saying. Do not hear me say, do what you want and let them figure out if they've got the legal wherewithal to defend. I'm saying operate within the bounds of the law as it is clear. In the areas in which it may not be clear, I say operate in your best interest and be prepared to defend your actions through best practices that I'll get to when we get to the section of tips and tools to weather the storm. Here in explaining the changes, and I do apologize that I'm jumping around because it is difficult to explain a massive federal act that was passed in the course of 2 weeks without industry input, without opportunity for attorneys to review the changes, get some federal guidelines. We're essentially doing the best of what we have under the circumstances. But what is clear is that for federally backed mortgages, the covered dwellings identified here, which I'll cover in some more detail in the next slide, that evictions are under a moratorium. That means that's suspended. You cannot initiate a new action between March 27th and July 25th for any covered dwelling. In simple terms, it's pretty clear. Additional restrictions on a covered dwelling: you may not issue a notice to vacate until after the moratorium is ended. You may not evict a tenant except with 30 days notice. You may not post a pay or quit notice or notice to vacate for non-payment of rent. And you may not charge late fees, penalties, or other charges due to non-payment of rent. Again, it does not say that these charges may not accrue due to non-payment. And I'm going to encourage people to operate in accordance with the terms of their lease, with accordance of the VRLTA, which also has not been suspended by this act, and using reasonable accommodation and best judgment, typical best business practice for property managers and landlords. So covered dwellings and covered properties are sort of two different categories that I'm lumping together here. You can think of it in terms of, is the tenant under a federal program? If the tenant is under a federal program or a state equivalent, such as we had, I think, at our meeting 2 months ago, a representative from the Virginia Housing Choice Voucher, which that term, I believe, is replacing Section 8. So if you've got either a federal or a state version of an HCV tenant, or any of the other tenants that are, I don't know if let me know if you can see my highlights here. Oh, nope. Sorry about that. Thank you for bearing with me. Can't highlight at this time. So I sort of did it backward with what was on the slide. You got your property, and if your property has a mortgage that is federally backed, which you may not know, you may not have gotten your mortgage with Fannie Mae or Freddie Mac, but they may have bought it at some time. So this part is not clear. And again, this may be a matter of a defendant at trial raising this concern. But if your property is backed with a federally backed mortgage, if it's a VA, yes. HUD, yes. FHA, yes. That's entirely clear. The federal multifamily apartment loans, those are clearly covered dwellings for the purposes of this act. Your property may, if you still have a mortgage on it, be backed by Fannie Mae or Freddie Mac, even if it's not one of these other programs. Now, you can check with the lender. That would be doing due diligence. You could leave it as a matter of defense to be thrashed out later. I think that's a risky venture, but it is an option. But if you own your property outright, then you don't have a federally backed loan. So this act does not apply to landlords or property managers managing properties that don't have a federally backed loan. So if it's owned free and clear, it's not a covered property for terms of the loan, or excuse me, a covered dwelling. Again, however, there's all those additional sections of federal code that provide tenants with protection. So you need to know your property and you need to know your tenant. If your tenant is under one of these covered programs, Section 8, HCV, Section 202 for the elderly, Section 811 for disabilities, the Section 236 multifamily rental housing, the rural housing voucher, the Violence Against Women Act, housing opportunities for people with AIDS, low income tax credit, and the Fair Housing Act may extend some of these even further. That part is not yet clear. That would be your two-step process to understand whether this CARES Act applies to you. I think for many of our local landlords where there's mortgages on the property, you need to do basic due diligence to understand if you have a clearly federally backed mortgage, a HUD, an FHA, or a VA loan, then know that you're covered and this act applies to you. If you have another conventional loan that may or may not have been purchased by Freddie Mae or Fannie Mae, it looks like we got a typo on this slide, Fannie Mae or Freddie Mac, you might want to check with your lender and find out if that is the case. And then separately, know your tenants. It's your responsibility to know if your tenant qualifies, and this is something you probably did in your vetting process in signing your lease. If your tenant qualifies under one of these programs, then this law applies to you. Okay, this is the language that I just meant that I just walked through about charging late fees. You can't charge them, but it's not clear if they can accrue. This slide, if you want to go back and look at this, is recorded later. Kind of just does a pretty good walkthrough as to how to assess whether the act applies to you. All right, we're going to shift gears into the avoiding liability and best practices. That was my best stab at explaining the federal law and the state law and how it applies to you. We're going to shift gears here into avoiding liability and best practices. I'd like to start with a couple of basic tips for landlords and property managers. Look to your agreement. Do not create liability for yourself by failing to abide by the terms of your property manager landlord agreement. That will still bind you. The contract still determines your authority and your responsibility as an agent of the landlord. Secondly, refer to the lease. That will determine that, and the VRLTA determines your responsibility to the tenants. Don't give legal advice. Tenants may come to you with questions. I anticipate, I don't have the chat window up, but I anticipate you who are business owners and experienced in this area are going to have questions. I'm an attorney and I'm reading this law and I've read it a dozen times by now and I have questions. So it's very likely that your tenants are going to have questions. Don't give legal advice. Encourage them to consult an attorney, and no self-help. That is forbidden in Virginia under normal circumstances. That means no turning off the water, no change in the locks. No, there's circumstances in which the locks can be changed that I won't get into, but no turning off the water. You still have a responsibility to maintain fit and habitable circumstances as a landlord under the VRLTA, and that responsibility has not been changed. We're going to discuss a little bit of specifics when it comes to needed repairs and concerns about COVID-19 contraction. I've got some of that later in the presentation, but that's some opening advice. Don't exceed the authority of your property manager landlord agreement. Look to your lease, look to the VRLTA to determine your responsibilities to the tenant. Don't give legal advice and avoid the temptation to self-help. So some tips, some things that you can do is be proactive. You can take, and I've had clients who before the CARES Act came out have come to me to review their proposals for rent deferral or reduced rent payment, when it wasn't clear how long the crisis was going to be, saying, hey, we're gonna not waive April's rent, but we'll give you 3 months to catch up. We're gonna defer that. That is one idea. I've got some links at the end, if I can get them to link, that it worked earlier, that I'm going to take you to the Virginia Realtors page where they drafted a couple of rent deferral forms. Again, anything that you do to modify the lease, get in writing. Make sure you have authority from your property owner and make sure you get it in writing from the tenant. It is up to you and your landlords whether you are willing to defer rent to after the emergency period, to create a catch-up period, to waive rent, to provide a reduced rent, or you don't have to do that at all. There's nothing that obligates a landlord, a property owner, a property manager to accept less than the contractual agreed upon amount. I had drafted notices for landlords prior to the CARES Act that had interpreted the governor's order and the Supreme Court's announcement and made it clear that the rule of law has not been suspended during this crisis. It is my understanding from reading through the law that the responsibility to pay rent is still in force, and failure to do so results in liability to the tenant. And I don't believe that there's any legal liability for reminding tenants of that. Your ability to kick them out has been taken off the table. But your ability to collect rent later that is due and owing is still for now available, or at least I don't want to say threat, the informing them of that responsibility. Yes, to understand the tenant is under no obligation to accept any no terms of lease, and neither are your property managers, but it is going to be, I think, in many cases for tenants who are experiencing COVID-19 related income loss to modify the lease. Make sure you get it in writing. Tenants' rights and obligations. Tenants still obligated to pay rent, abide by the agreement. Tenant is still obligated to report emergency needed repairs and still obligated to allow access to do emergency repairs. You still have responsibility to protect the property and the value of the property for your property owners. Tenant must still follow the lease, not be in breach for pets, nuisance, domestic disturbances, etc. One thing I'd like to point out is that the moratorium was specific concerning non-payment of rent as a basis for unlawful detainers in the Virginia case. It did not say that you could not file unlawful detainers for other breaches of the lease, destruction of the property, subletting, letting 15 people there. They can't use the property in violation of the governor's executive order either. That would be a breach of local and state law, which most of the leases prohibit. Again, if you're a covered dwelling under the Federal CARES Act, if you have a mortgage on the property that falls under this, then those rules apply. But under the Virginia declaration, it is very specific that unlawful detainers for non-payment of rent have been suspended, but not other breaches. You can see here a reminder of the responsibility to provide emergency repairs, fit and habitable circumstances. We're going to be shifting to warmer weather, and that means, HVAC, you're going to get a lot of calls. Now, the willingness of folks to go out to properties is, may be limited. So there's going to need to be reasonable responses on all sides. So I will limit my comments to this to merely explaining the law, that the responsibility to maintain fit and habitable circumstances to include HVAC in most cases is still in force. I would encourage best practices to limit exposure and follow CDC guidelines. There's not a provision in these laws that empowers a tenant to deny access to a landlord for emergency repairs. That being said, I had the cable guy come to my house last week and said that his company prohibited him from setting foot. And so he had to I guess you can't see my hands here and I don't have the wire in my hands, but the cable guy was pushing wire through the wall and talking to my wife through the window on how to set up what needed to be done. And so you may get some need for compromise on both property managers, repair mechanic folks, and tenants. And just you're going to have to use best judgment because the law is not clear on this. But following CDC recommendations is probably going to be your best bet as far as leaning on that. Communication is going to be your ally in this. Communication in writing, document. Do not exceed the authority of your landlord property manager agreement. Refer back to your landlord, keep them informed, and being open with your tenant and reasonable with scheduling for this sort of thing. Showings and open houses. So the first three bullets on this slide we've already covered. Showings and open houses. You are still allowed to sell. Our office is open. We're doing real estate closings every day. The law is not clear. The CDC guidelines. Good job coughing your elbow, Lee. So it looks like somebody's been up to date with the CDC guidelines. That's well done.
No doubt.
We're doing virtual closings. I'm using this camera to do our closings while our signers are in the next room. But yeah, real estate's still open for business, and you probably have sellers who want to sell. My guess is that you're going to have I'll stick to what's on the slide. Follow state and local guidelines and CDC recommendations. The seller still has the right to show the property, but to respect the tenants, desire to protect themselves from exposure, especially for at-risk populations. Short-term rentals. This is a good one. I really have to thank my assistant. This is a great time for me to thank my assistant, Jeanette, who helped me with preparing this presentation. She brought to my attention that Virginia is a vacation destination. Looks like Tracy's on the beach. I don't have that filter for my Zoom application, but it looks like you're enjoying some cool breezes and some nice sunshine. And depending on where in the country the vacationers may be coming, don't make a presumption that your short-term rental folks are familiar with our state's obligation. Assume the responsibility to communicate ahead of time in order to avoid liability after the fact. The beaches are closed for sunbathing and recreation. They're open for exercise and fishing, but not sunbathing. So think about our properties in Sandbridge for our Virginia Beach folks, where you've got houses that are party houses. I don't mean that in a bad way, but graduation parties where they're set up to have 2-3 families come in town. That's going to exceed the governor's guidelines on no more than 10 people in a place. You're going to want to get out ahead of that and communicate to tenants. When it comes to campgrounds, and we'll see how this is applied, 14 days stay minimum, no overnight. So look to your local guidelines. If you have a question in your individual jurisdiction, call the city and see how they're interpreting this, because we don't have a lot of clarity on this. But I'm going to tell you that your best practice is to inform your incoming tenants of what to expect, what the current regulations are, what's open, what's closed. Because I know that if I were vacationing, say I'm coming from a place like Montana where there's not a big outbreak, and I'm looking forward to my Outer Banks, my Virginia Beach vacation, and I show up and I can't go to a restaurant, I can't, sit on the beach, I'm probably looking for my money back. And you can avoid some of that after the fact dispute by being upfront with what the circumstances that your out-of-state visitors are going to be encountering when they get to Virginia. This is actually, I thought I had hidden this slide. Can you guys see this slide? I think you can. It looks like I can on my screen. As a reminder that the law concerning selling a property subject to the lease is still in place. You may have owners. It's coming up on summertime. Traditionally, spring, you're getting a lot of properties listed, including those with leases. You're not going to be able to evict tenants. If you had a tenancy that ended April 30th, May 31st, with the landlord planning on showing you can work out a written agreement. Hopefully you've got tenants who abide by the lease. You probably have owners who want to sell. Again, self-help is forbidden. You're not going to be able to evict. If you get people who voluntarily leave at the termination of the lease, great. You can't modify a lease clause, and when you have a carryover tenancy, which is what's going to be created in a number of these cases where you have leases set to expire and tenants who refuse to leave, you're going to be bound by the terms of the lease, and what is going to be considered due for rent is going to be based on what the month-to-month rent was in the previous term of the lease. Again, communication is going to be the best bet here. Communicating with tenants, communicating with landlords, communicating with prospective buyers. This is a reminder that the governor just signed into law a number, I think it was yesterday or the day before, it couldn't have been the day before, that was Sunday. It might have been Friday. The governor in the last week has signed in a new raft of provisions that affect landlord-tenant law and property law. These have been voted by the new General Assembly. And we're going to be having a rollout brief similar to this webinar by some of our attorneys here at Hanger Law. So stand by to see how and when, if this rollout that was supposed to go into effect in July of this year, if that gets modified. But my feeling is it's probably going to go forward. We will do our best to keep you informed as that happens. So here's another tools and resources, and I've provided some links at the end of this brief. You may, depending on how your business is formed, have access to both Virginia and federal relief as a property manager, as a landlord, as a business owner. Even S Corp, sole proprietorships, can take advantage of unemployment insurance, for instance. You've got a couple that are on here. You can get a deferral of state taxes, as identified on the slide. The federal tax deadline has been extended as well. Note at the bottom, see the interest will still accrue. So if you have the ability to pay the taxes, it's going to be in your best interest to do so, but you won't be penalized if you're late. The interest will be there, the penalty won't. There's an extension due to the COVID-19. Let's see what else we have here on the resources. The SBA loans. So if you are set up as an LLC prior to some date in February, you can't have set up as an LLC, you can't have set up as a business after the COVID crisis started to avail yourself of the small business loans. This is an area of a mix of, again, federal and state law, where because Virginia was declared a disaster, the Emergency Economic Injury Disaster Loan Program, the EIDL, is available to business owners. It's federally backed and state administered through local banks. That is going to be something that exceeds the scope of going through the details for this presentation. But if you would like some assistance or some counsel in applying for the Paycheck Protection Plan loans or the EIDL loans, that is something we'd be happy to provide some assistance or at least direction on how you can help yourself, or if you need help, we can help. Let's see. Other ways that you can, is a reminder of best practices, is review your lease agreement, review your property management agreement. You can rely on us, or if you already have an attorney, to review your posting notices to ensure that you avoid creating liability for yourself in violation of the law. Advise you regarding the individual circumstances if you have tenants who refuse to pay rent or tenants who refuse to provide a reasonable request or modification that you offer them. You may need some substantial help in navigating your relationship with landlords who are not being paid rent. And we are happy to aid you in formulating communication that informs them of the law. A lot of our landlords here are not the monopoly man. They're not, don't have a row of Trump hotels. These are middle-class folks who rely on the rent to balance their own family budget. And when that doesn't come in, that's going to be a substantial hit. And that's going to affect your business model. That's going to affect them. And you're going to need to be prepared to answer some of those questions. And we were happy to come alongside you and equip you for that task. Help in negotiations and out-of-court settlements for past due rents. This is going to be a big one. The courts are going to be swamped when this moratorium is lifted. When the state emergency is lifted, my guess is the courts are going to be swamped and backlogged. And it may be in your best business interest to settle some of these matters out of court for a reduced amount of what's owing. That may sound like a bitter pill to swallow for coming out of a market that has been pretty favorable and profitable for a substantial period of time. But I would encourage you to consider pivoting towards survival, looking at some of these additional business loans, looking at this as income where you can, and see if you can get this replaced under the small business loan and take reasonable settlements when presented. Again, it's going to vary in individual circumstance. I cannot provide a one-size-fits-all advice, but I would encourage you to open your aperture as far as tools and resolutions on the table to include reasonable settlements for amounts of rent that may be less than what's truly due and owing versus the cost of litigating that out and the delay that I anticipate that you'll see at court. Happy to explain what are emergency repairs and what aren't, what's a reasonable time period, how to, again, guide your clients through stay on foreclosure. Now, that's a different area of law. That's a good point. I'm sorry, that's a good pivot. So there's a 60-day stay on foreclosures for non-payment of mortgages. Now, I would encourage you as property managers in relation to your landlords, if you are not getting rent, to encourage your owners to be proactive with their mortgage lenders about the state of the situation. There are loans available and relief available through lenders regarding mortgage relief and foreclosure avoidance and defense. That is going to be an individual situation depending on number of properties owned, number of lenders involved, etc. But be aware, yes, there's a 60-day moratorium on foreclosure, and you're going to have landlords who are making a decision of, do I walk away from this property? Do I keep this investment property based on whether they're getting rent? So there's going to be a number of trickle-down effects, and where the relief comes is not, again, streamlined. It's not seamless, and is going to be an individually tailored situation. But there's going to be opportunities, I believe, for loan modification, short sales. There's going to be options on the table. And it seems like the money is at least getting to the banks, even if there's a backlog on the loan application downstream. Another option, there's a possibility that this is not the last raft of relief that's coming. There's talks about another stimulus bill, and it may be in your best interest to set up as an LLC. We know that most realtors are 1099 subcontractors. There is unemployment insurance available, though it's been made clear that it is available. The Virginia Unemployment Commission has not caught up with the backlog of applying that. So that's as of last night, that's what I've read, is it is clearly available that this additional unemployment insurance, the extra $600, this is available and expanded to include subcontractors, including realtors. However, though it's legally authorized, the implementation has not yet caught up with that. We are happy to talk to you about setting up as an LLC to avail yourself of an increased liability exposure protection and subsequent, and this is speculation, subsequent federal relief as it comes down the pipe. If you weren't set up as of February, and I don't have the exact date in front of me, you're not going to be able to avail yourself of some of the small business relief, the forgivable loans, but there may be more coming, and it may be time to consider how you're structured as a business. Here, these are hyperlinks. I'm not going to try to open these, but if you want to read for yourself, these are the sources of Virginia law change. You can go to the governor's website. There's both the press release and the text of the executive orders. This is the text of the judicial emergency. I have excerpted some of that information earlier in the slides. But I think everybody else is on mute. I'm under the impression this is recorded and I can make this available. Here are additional professional resources that I want to take a minute and highlight if I can open the link, and I believe I can. There we go. The Virginia Realtors, does everybody see that screen? Lee, can you nod if you see the Virginia Realtors screen? Thanks, Tracy. Thanks, Lee. All right. Here are updates. This is very, very helpful for both property managers and realtors. I'm going to pull up a couple of forms. This is a rent alteration request. You can certainly come up with your own form that meets your business model, your landlord and your tenant agreements purposes, but you don't have to reinvent the wheel. Here is a rent alteration request that you can provide to your tenant, or your tenant may have found on their own, that would give you the opportunity to document the need for an adjustment. Here is a lease rent alteration amendment that will amend the lease. Now, this may be extremely helpful because you don't want to kind of freelance a legal modification that will then suspend or supersede the terms of the lease when that's not your intent. Maybe it is. If that's your intent, go ahead with it. But if it's not your intent, if your intent is to address a temporary problem with a temporary solution, then I'd encourage you to use this form. And you're welcome to come to us. I would be happy to review any documents that you have. I would be happy to provide tailored counsel based on your circumstances. But in absence of an attorney, this is a pretty good form that allows you to use something that's already been drafted and approved by the Virginia Realtors Association that can essentially keep you from having to reinvent the wheel. Depending on the number of properties you have, it may make sense just to use a standard form. There's additional resources here. Provides information on unemployment assistance that I discussed just a minute ago, the financial assistance and loans that are available to small business owners, property managers, landlords. I'm not going to go through the FAQ, but I would encourage you to go here. You see this up here, virginiarealtors.org. There's one other specific one. Property management, that's what I was looking for. We've got the download forms. This explains how the documents work. This provides some guidance regarding avoiding liability regarding repairs. This is a good question here. Do you have to use the hold harmless language? If so, do you need to go back and add this language into brokerage agreements that you've already entered into? The short answer on this is no, but it may be wise. You don't want to create additional liability for sending a contractor into the house to perform a repair. God forbid that person be infected with the virus and infect your tenant. That's going to exceed the scope of typical landlord liability. Virginia is not exactly California when it comes to how liability is assessed, and the rules for medical malpractice, products liability, et cetera, are fairly tight. That being said, if you want to protect yourself and use a hold harmless agreement, it wouldn't be a bad idea. You can see this is a pretty short answer. No, this language is not required. The risk of your liability in circumstances is very low, even without this additional language, but you can add it if it makes you feel safer. It may just make you, the tenant and the landlord, feel safer if you include that language in. This provides additional Q&A regarding unlawful detainers. Again, keep advised of the news. This is subject to change. Here's a good question. What happens when my tenant can't afford to keep utilities on pursuant to their obligation under the lease? Many utility services are offering some sort of limited protection against terminating services during this public health crisis. In addition, the State Corporation Commission issued an order on March 16th, coinciding with the governor's executive order and Virginia Supreme Court emergency declaration prohibiting any utility cutoffs for at least 60 days. If tenants have questions on this issue, they should contact their utility provider directly. Here's another good question when it comes to disclosure. A COVID-19 diagnosis is not a required disclosure. I would encourage property managers to deflect and defer any questions about other tenants as outside your purview. It is not clear that there are, HIPAA and privacy has not clearly caught up with our current crisis, but I would encourage you to avoid making any sort of speculation, saying just refer to the fact that you're not a medical doctor and that it's not your responsibility to keep track of the medical conditions of the people in the property. Certainly, you have an obligation for fit and habitable circumstances, but that doesn't extend to the individual health of tenants. And I would encourage any tenants that came to me with questions back to the CDC guidelines and local and state resources as how to minimize exposure. But you should avoid speculating as to the health and wellness of your tenants. It's not your job to know whether Billy's cough is seasonal allergies or something else, and I wouldn't go about guessing. Here's another great question. We're closing down our property management office to the public for the next 4 weeks and would like to require all tenants to pay their rent online from now on. Can you do that? The short answer is look to your lease and look to the obligations of your property manager landlord agreement. You can, you have that flexibility, but you probably are under best practices if you make reasonable accommodations for a drop-off point, PO box, something along those lines, if it's available to you. Cleaning standards, if you have tenants moving out and tenants moving in regarding COVID-19, there's no heightened cleaning requirement. Use your best judgment, reasonable accommodations, but that is not your obligation. That's probably the best. I'm going to see if I can get that PowerPoint back up on the screen. And I am open for questions. Lee or Tracy, the chat, I don't want to jump around here. Should I just click?
I'm going to help you with that.
Thank you so much. That would be great.
So Jeff had a question. Does Federal CARES Act pertain to commercial leases? I think Tyler chimed in and said, no, it does not. No. Do you have any advice for those with commercial leases at this point?
So the answer is correct. The CARES Act does not apply to commercial leases. You can still file unlawful detainers in a commercial lease setting. However, local courts may be rejecting those. We've had some where we have attempted to file with July dates, August dates, where it has been returned unopened. And I'm not going to name names. I'd encourage you to contact your local court clerk's office. In most commercial lease settings, you are dealing with a business owner tenant and a business owner landlord. And so there are relief measures aimed at providing money, forgivable loans, specifically for paying the rent for small business owners. If I had a client who's a commercial landlord and had a non-rent paying tenant, I would encourage him to send a strongly worded letter pointing that business owner to the fact that the four corners of the document are still enforced, the rule of law has not been suspended, and he has additional resources specifically for the purpose of paying the rent. That's my best short answer to that question.
Awesome, thank you. There's some questions about non-renewal. So here's one. My understanding is that any notice to vacate, such as a non-renewal of a lease, is not forbidden. Only rent payments related notices.
So the 30-day notice language in the CARES Act is somewhat ambiguous. It clearly does apply to non-payment of rent circumstances. It says that the tenancy cannot be terminated without 30-day notice, and that the 30-day notice shall not issue during the moratorium period. However, it is somewhat silent as to non-renewal. I would interpret that silence is to saying that you are not terminating the lease, you are reminding them of the agreed upon termination date. I would avoid language in which there's threats of litigation, such as an unlawful detainer, for failure to observe that. So my advice to landlords in that situation is be as sparse as possible in your language, refer back to the lease as much as possible, and avoid making threats for eviction, which you can't carry out.
Awesome. There's also some questions about tenants that are in place, the 60 days notice before they vacate. Again, many refusing to comply with showings due to the health concerns of strangers in their home. So I know you kind of briefly talked on that. Do you want to just?
Sure. It's a great question, and I don't have an easy answer for that. Obviously, health and safety is going to be paramount. However, landlords and owners have an interest in selling their property. I would encourage open dialogue in trying to seek appointment times where the tenants may be out of the property. I would point back to CDC guidelines. I can't encourage people to buy masks because you can't find them. But that is going to be, this is pure speculation. I have to be clear on this. I have a feeling that the courts are going to be very slow to fault tenants who raise legitimate health and safety concerns for denying access for that purpose. Again, you can remind the tenants the lease is still in place. There may be an opportunity to pursue liability after the fact through a warrant in debt if damages can be proven. This gets into kind of some more in-depth legal analysis that is not based on established case law because this is a brand new circumstance. So I don't have great advice. My best advice would be to seek through communication reasonable accommodation for tenants and remind them that the lease still controls. Again, you can't threaten to evict them, but you can remind them that they are still responsible to meet their obligations under the lease.
Awesome, thank you. Here's some out-of-state visitors sheltering for 2 weeks. However, most reservations are for 1 week. Does this apply to all house rental guests or just to campgrounds? And then another person kind of asked about guests limiting to 10 or less family members in a vacation home.
So I touched on the second and not the first. That's a great point. That is one of the guidelines is a self-quarantine for 14 days for for out-of-state visitors. That's tough. That is the executive order. The other one of the 10 or more, that I think that your best bet on here is going to be to inform out-of-state tenants of the law, point them to the governor's webpage, encourage them to review it for themselves, give them the summary. And then I think that this would be an area in which there is clear lost income for those business owner. I'm sorry, I was getting text message questions as well. For the landlord and the property manager, I think this is going to have to be liberally applied when it comes to lost income, unemployment for these businesses. I don't have a clear answer for you yet because we're still in the first weeks of the rollout of this relief program. But my sense is that you're going to get cancellations because of this, and that should be subject to either the forgivable loans or the emergency disaster relief loans or the unemployment, and possibly two out of the three. There's nothing in the language that prohibits application for both, or two of the three rather.
Awesome. Well, thank you so much. This has been a wealth of information, I think, for all property managers. It looks like we had 89 people on our Zoom meeting today, which is amazing. So thank you all for joining it. Let's give John a big round of applause. Yay, thank you. I know you mentioned VAR, and that is another source of information. And on Tuesdays and Thursdays, they have meetings on Facebook that you can attend. I know the next one is today, Legal Live with General Counsel Laura Farley, and that starts at 3:30 today on Facebook and I believe through their website. So thank you for also including VR because they
Great.
also, I'm sorry?
It's a great resource. I'm sorry I spoke at the same time.
No, it absolutely is. And again, they have those two meetings on Tuesdays and Thursdays. Again, don't forget about our next Zoom meeting. HRR's next Zoom meeting with attorney Brett Thompson talking about closing in the time of COVID-19. And that again is on April 23rd, 2020. This has been recorded. This will be shared. You will probably get an email with the presentation. And again, this will count as part of your circle of excellence attending a meeting. So thank you all. John, do you have anything else you want to say?
I would just encourage you to stay the course. Property managers, landlords, you are providing a valuable service. You are employing members of the community. You are keeping housing open for tenants. I consider our small business owners, our landlords, property managers to be people who are truly on the front lines. And you are the ones who have built our local economy to be as strong as it is. And it's going to be on your backs that we recover from this. And if there's a way that we can come alongside you and equip you to both weather the storm and bounce back stronger than ever on the other side of it, we would love to partner you that. Stay the course, stay strong, and stay abreast of the law.
Awesome. Thank you, John. Thank you, everybody, for attending. We might do another one of these next month, so we'll keep you posted. If you have any feedback, you can send me an email, tlewis@remax.net, or put your email questions to the original. When you signed up, there was an email address. I think it was, you'll have that as well. So great job. Thank you, everybody. Have a great day.
This was great.